This case arose from some disgusting behaviour by some very bent coppers in Western Australia. Trobridge was a taxi driver. In the 1950s, taxis were not allowed to ply for trade. They had to wait until someone hailed them. Two people did hail Trobridge, and he pulled up to let them in. Two police approached him and demanded that he provide his name and address. He gave them a card with his name and address and then asked the coppers to wait while he obtained the details of the two passengers so that they could be witnesses. Instead, the coppers arrested him for failing to provide a name and address. They took him to the station, refused bail, put him in the cells and beat him. Trobridge sued the police for assault and false imprisonment. The police relied on a section of the Police Act which read, "No action shall lie against any officer of police on account of any act, matter or thing done in carrying the provisions of this Act into effect against the parties offending or suspected of offending against the same, unless there is direct proof of corruption or malice." The problem is that the only direct proof of malice is a confession by the malicious person. Malice is a state of mind, and nobody can look into the mind of another person. The trial judge accepted that there was malice, but the proof was indirect, and so the judge dismissed the assault and false imprisonment claims. The High Court judges were not going to let this bent copper get away with it. Justice Fullegar applied the statutory interpretation principle that acts should not be presumed to remove fundamental common law rights. He observed, "The mere interference with the plaintiff's person and liberty constituted prima facie a grave infringement of the most elementary and important of all common law rights." He then said, "It is not easy to suppose that the Parliament would really intend to give public officers immunity from civil liability for damage caused by malicious conduct, however convincingly the malice might be proved, except in the odd case in which the guilty officer is sufficiently accommodating to condemn himself." Instead, the court read the provision down so that it did not interfere with the common law protection of the person, and allowed proof which, while not direct, was convincing. They awarded Trowbridge damages and costs.